Hello everyone, and welcome to the March 2022 episode of my PIP Monthly. My name is Amber Rouse Holloway, and I'm a partner here at our Troy office. Our March 2022 topics, we will discuss, of course, a case law update. First, we'll talk about the published opinion, Misha Levy, MAIPF, and then we will go on to discuss Canary v. Liberty Mutual Insurance Company. And then lastly, for trending topics in PIP litigation, we will move on to the Tusignant v. Allstate and its intertwinings or interdwellings with MCL 500-3109A. First up, Misha Levy v. MAIPF. This is the first published opinion in Michigan to consider the issue of discoverability of a retained expert's financial information. The Court of Appeals generally has made this a case-by-case determination depending on the balancing of interests, including privacy interests of the expert and the seeking party's need for the information. Overall, this case is dealing with MCR 2.302b4, which limits the means of discovery about or from expert witnesses, but provides that the court may order further discovery by other means upon a motion. Ultimately, the court here held that information such as an expert's financial documents, including medical evaluations, deposition, trial testimony, may be discoverable, but the trial court must balance the burden of the proposed discovery against its value. By way of background, in the trial court, the plaintiff here issued a subpoena to Ability Assessments, seeking the financial records as well as a number of independent medical evaluations performed by Dr. Mary Nizer at Ability Assessments in the last 4 years. They asked for the number of patient examinations conducted by Dr. Nizer at Ability Assessments in the last 4 years as well. Defendant Citizens Insurance Company moved to quash the subpoena, arguing that pursuant to MCR 2.302b4 Section A, plaintiff could not seek the requested information by subpoena without first seeking leave of the trial court by motion. That records of the numbers of her patients and IME examinations were relevant to the issues in the case, and that the subpoena merely sought to harass, embarrass, and dissuade participation in the litigation process and would ultimately impose an undue burden on Dr. Nizer. The trial court denied Citizens' motion to quash, as well as its motion for consideration. Thereafter, Dr. Nizer and Ability Assessments as non-party appellants sought leave to appeal to the Michigan Supreme Court, and the appeal was obviously granted. The majority of the Court of Appeals first analyzed the applicability of MCR 2.302b4, which, like we said, limits the means of discovery about or from an expert witnesses, but provides that the trial court may order further discovery upon motion. The majority also noted that this court rule only applies to facts known or opinions held by experts that were acquired or developed in anticipation of litigation, not just to any and all information possessed by an expert. Ultimately, the majority found that the information sought was relevant here because it had a bearing on Dr. Nizer's credibility, and the information that bears on a witness's credibility or bias is never irrelevant. The Court of Appeals also considered the appellant's contention that the subpoena should have been quashed as unreasonable or oppressive, and they concluded that the trial court's analysis in this regard was inadequate, opining that the plain language of MCR 2.302b1 clearly obligates the trial court to balance the burden of the proposed discovery against the value of the proposed discovery. They then remanded the matter to the trial court to balance the value of the plaintiff's proposed discovery against the burden of this discovery, including addressing non-party appellants' privacy concerns and the practicality available of alternative means for plaintiff to obtain the information. Next up, we have the case of Canary v. Liberty Mutual Insurance Company. Ultimately here, this case centers around plaintiff's arguments that she was entitled to have a Maryland policy reformed to comply with the requirements of Michigan's No Fault Act under MCL 3012. By way of background, this case arises from a November 2017 motor vehicle accident in Michigan. Before the accident, plaintiff obtained an automobile insurance policy from defendant, and the policy reflected that plaintiff's mailing address was in Maryland and that she had a Maryland driver's license. According to plaintiff, she moved from Maryland to Michigan approximately 1 month before the accident and informed defendant's representatives around that same time that she was moving to Michigan. The plaintiff then provided defendant with her mother's address in Van Buren Township. Fast forward to November 2017, plaintiff was involved in a motor vehicle accident. Plaintiff filed a claim for benefits under her policy with defendant. Consistent with the policy and consistent with the Maryland policy of insurance, defendant paid the plaintiff the $2,500 policy limit. Plaintiff then sued defendant, alleging that defendant had failed to pay plaintiff PIP benefits under the policy and in accordance with the Michigan No-Fault Act. Defendant then moved for summary disposition, arguing in relevant part that the Maryland insurance policy did not provide PIP benefits beyond the policy limit of $2,500, and that defendant was not required to comply with the Michigan No-Fault Act because plaintiff was not a Michigan resident. Plaintiff argued that she did inform defendant that she had moved to Michigan before the motor vehicle accident, and she believed that her Maryland policy was then converted to a Michigan no-fault policy. The trial court granted summary disposition in favor of defendant, concluding that plaintiff had a Maryland policy at the time of the accident. This appeal followed. MCL 500-3012 governs the issuance of non-compliant policies. It states that liability insurance policies issued in violation of MCL 500-3004 through MCL 500-3012 of the No-Fault Act shall nevertheless be held valid but deemed to include the provisions by which required by such sections, and when any provisions in such policy or rider is in conflict with the provisions required to be contained by such sections, the rights, duties, and obligations of the insured, the policyholder, and the injured person shall be governed by the provisions of such sections. The court highlighted the case of Farm Bureau Insurance Company v. Allstate Insurance Company, and explained that it is evident that the basic purpose of MCL 500-3012 is to treat an insurance policy that an insurer issues purporting to be a Michigan policy that complies with Michigan law as such, even if the written terms of the policy are inconsistent with Michigan law. However, an out-of-state insurer is not required to provide Michigan no-fault coverage if the policy is issued to a person who provides no indication to the insurer of being a Michigan resident. If the out-of-state insurer does not or has no reason to know that it's dealing with a Michigan resident, the policy will not be construed to contain the missing provisions of the No-Fault Act, which here are the payment of PIP benefits after $2,500. The court reasoned that in the instant matter, there is no dispute that defendant properly issued a Maryland policy to plaintiff, who was a Maryland resident at the time the policy was issued. Plaintiff's argument on appeal is that she informed defendant during the policy year that she was moving to Michigan and that she believed the information she had provided converted her out-of-state policy to a Michigan policy. Although plaintiff presented an affidavit, there's no evidence that defendant issued another policy that purported to be a Michigan policy. Indeed, plaintiff provided the Maryland policy of insurance to law enforcement at the time of the accident, and because there's no evidence that defendant known or should have known that it was issuing a policy to a Michigan resident, neither MCL 500-3012 nor the court's opinion in the previously cited Farm Bureau case support that plaintiff is entitled to relief. Moving on to trending topics in PIP litigation, today I wanted to talk about the Tusignant v. Allstate case and MCL 500-3109A. Pursuant to the Michigan Supreme Court's ruling in the Tusignant case and MCL 500-3109A and the terms of most policies, a plaintiff must submit their charges to their health insurer carrier on a primary basis before payment of medical expenses shift to the coordinated no-fault provider. So this is the case when you have a coordinated policy that is obtained at the issuance of a policy and that the plaintiff or insured receives a lowered rate or deductible for coordinating the benefits. So payment first falls to their health insurer, and then the no-fault insurer pays what is left over after payment by the health insurer. MCL 500-3109A provides that an insurer providing PIP benefits under this chapter may offer at an appropriately reduced premium rate, deductible, and exclusions reasonably related to other health and accident coverage to the insured. Any deductibles and exclusions offered this section are subject to prior approval from the commissioner and shall apply only to benefits payable to the person named in the policy, the spouse of the insured, or any resident relative. So here it's basically saying that you can coordinate benefits and receive a reduced premium rate, but that coordination only applies to the named insured, the spouse, or resident relative, so not to any third parties or innocent third parties. The Michigan Supreme Court has used the two signat opinion to provide summary disposition in favor of defendant when in appropriate matters, when a plaintiff is required, when a plaintiff has coordinated their benefits and has not submitted the charges to their health insurance on a primary basis or before submitting them to the no-fault carrier. So what happens here is a plaintiff or a provider may submit their charges to the no-fault insurer more. So it's like they're trying to bypass the health insurer because the health insurer obviously pays at substantially lower rates in comparison to the no-fault insurer. So in practice, when you see these coordinated policies and you have a plaintiff who is a named insured or spouse or resident relative, it's important to order the insurance policy and specifically order the summary plan description, because sometimes when you order the policy, you'll just have the policy language. You won't have, for example, a deck page that talks about what has actually been submitted. And sometimes you'll see these providers do this because they're out of network, which totally invalidates their claim, or like I said, because their charges are substantially less when submitted to a health insurer. This does not apply to Medicaid or Medicare. When you have a Medicare or Medicaid claimant, they seek benefits related to the motor vehicle accident from the no-fault insurer on a primary basis. And again, it does not apply to third parties or a passenger. Well, that wouldn't even be the case here because of no-fault reform, but it does not apply to innocent bystanders or innocent third parties at all. And these two signat motions are a very easy way to narrow exposure and to whittle a claim down. And it highlights what type of providers or what type of claimant you have, because if they're not submitting it on a primary basis to their health insurer, why not? And a lot of times that's obviously because they're out of network and they can't make their claims at all. So there's also an issue of an ERISA policy, but that's kind of a red herring issue. Some policies will state that health insurance policies will state that they are indeed ERISA policies, and then you'll read the language and kind of get deep into the language, and it won't be an ERISA policy. So that's when these motions become not so simple. But generally speaking, they are a very easy way to narrow a claim. But if you do have any questions regarding ERISA policy, I've read so many of them, and I filed so many of these motions. Please feel free to contact me, and I can review the policy and let you know my opinion on if a two signat motion would be beneficial. Most times they are, because it is, like I said, a very simple way to narrow exposure early on if you obtain that summary plan description very early on in discovery. And that is all I have for you guys today. Again, thank you for attending the March 2022 episode of My PIP Monthly. My name is Amber Rouse Holloway. Please feel free to contact me with any questions and concerns. Thank you.